It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like, how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my agreeable co-host, Brett.
Agreeable is what I thought. In my mind, I was thinking Alice is going to say agreeable. Not because I'm agreeable, but because puns. Gotta come up with a good pun.
The puns. You're not agreeable at all. You're actually the opposite of agreeable in a good way. In a good way.
Disagreeable?
Let's do that over. My disagreeable co-host. What happens when he's no longer agreeable and a judge strikes it down? Well, so we have been telling you guys for many episodes that we were going to talk about something that people have a lot of questions about, and that is plea agreements. And the reason you guys have had lots of questions about it is because, as you probably know, almost all criminal cases end in plea agreements. Very few actually go on to trial. So we spend a lot of time on legal briefs and also in our other podcast, Prosecutors Podcast, talking about trials, but those are really the exception. And so we can talk about whether that's a good thing or not, that most cases actually plead out rather than go to trial. But it's a reality of our justice system right now that most criminal actions end in plea agreements. And you guys have had a lot of questions about them, how they work, how you reach an agreement. Do you have a right to an agreement? What goes into an agreement? Can anything be in an agreement? So we are here to answer all of your questions.
Yeah, and just to jump off on something Alice was saying, I mean, the reason that the vast majority of cases end in plea agreements is because most people are guilty. Right? I mean, most people are guilty. Most times, if the police arrest you, if they've been investigating you, if they've indicted you in the grand jury, most people who are indicted by a grand jury are guilty.
Let me just qualify that real quick. Those of you who are just jumping in for the very first time and are about to go smash us on Reddit or something, the reason, and we've talked about this in other episodes, the reason most who are indicted end up being guilty and are convicted is because the prosecutor is the first line of defense, right? Well, actually the investigators are. But the prosecutor has the duty when they're investigating a case and deciding whether to bring a charge. They have the duty to not bring a charge if they don't think they have beyond a reasonable doubt. And so that's why. It's not that we think everyone who gets arrested is guilty. It's that the prosecutor actually is supposed to be the gatekeeper. They're not supposed to be bringing cases they don't think they can prove before a jury. And so that's a huge filter right there.
Yeah, I mean, look, it would be a big problem with the system if most people who are arrested, indicted, and face criminal prosecution were not guilty. That would be a big issue. Like if prosecutors were going around just indicting people willy-nilly and half of them are innocent and, man, we need to be going to trial as much as possible to vindicate their rights, that would be a huge problem. It's not to say that there aren't innocent people who are arrested. Obviously there are. And there are people who will say that there are innocent people who plead guilty because the danger of going to trial is so great. And we're going to talk a little bit about that. But I think it's hard to overstate how many cases. It's not like it is in Law and Order or any of the shows you watch on television. Most cases are pretty straightforward. I mean, you'll have a case Police stop a guy, pull him over, walk up, say, hey, is there anything I need to know about? Guy says, yeah, I got a gun on me. That guy's a felon. That's a pretty straightforward case, right? He's a felon in possession of a firearm. We know that. He just admitted it to the police officer. And those cases, he's probably not going to go to trial because what is his defense going to be? I mean, that's one of the things defense attorneys will often tell their clients. I mean, defense attorneys are often the people pushing the hardest for plea agreements because they're telling their client, look, man, there is nothing I can say. I can get up there and say, you jury, you need to hold the prosecution to its burden. They have to prove it. I can get up there and say that. I can always say that. But if you're looking for an actual victory here, that's just not going to happen given the evidence we have. And so I, as a defense attorney, am strongly recommending you plead guilty. We're talking to Bob Mata about the List case, and he was talking about that, even in that case, a murder case, sitting down with your client and really walking through like, hey, look, this is the situation you're facing. This is the stuff they've got against you. Maybe the best thing for you to do is just to throw yourself on the mercy of the court, and hopefully it works out. And we'll talk about that some more as we go, but let's get into a little bit about how plea agreements work. You might think that in order to plead guilty to something, you have to first be indicted for a crime, but you would be wrong. Actually, you can, and this often happens as well. Sometimes prosecutors will come to you and say, hey, they'll send you something called a target letter. And they'll say, hey, you're the target of investigation. We think you're involved in this. If you would like to come talk to us, it would be in your best interest to do so. You get yourself a lawyer. You go down to the police station. You say, hey, you got me. I did it. That was really stupid of me. It was a huge mistake. How can I help you in anything else you're doing? What can we work out? And when you do that, you don't even have to worry about going to a grand jury or indictment or anything else. You can actually plead guilty on something called an information, which is just a document the prosecution fills out that says, hey, this is what you did. You waive your right to a grand jury. You agree to plead guilty to that, and then you sort of move forward. So you don't actually even have to be charged with anything yet to go ahead and decide to plead guilty. But most times, most cases, you're going to have somebody who's charged in the federal system, which is what we'll talk about because, once again, 50 states, they're all different. Better just the federal system is one system. So we'll talk about that. Under the federal system, you have to be indicted by a grand jury. The Constitution guarantees you that right if you are charged with a felony. Not charged with a felony, if it's a misdemeanor, you don't have to be indicted by a grand jury, but we'll assume felony. So let's say you've been charged. Well, the first thing you can do is something called a blind plea. And a blind plea is when you just say, I don't want an agreement. I don't want to work anything out with you guys. I just want to plead guilty. That's what I'm going to do. I'm going to go in, I'm going to plead guilty, and I'm going to take my punishment. And Alice, why would someone do that?
So that absolutely can happen, right? Because first of all, you are not entitled to a plea agreement. A plea and a plea agreement are two separate things. A plea agreement is a contract with the government. A plea is your right as the defendant to say guilty or not guilty. And that's why you're always asked that your initial appearance, your arraignment, right? Right when you appear for the first time to be read your charges, you are asked, how do you plea? And by the way, we've talked about this before, like 100% of the time. I've actually never seen anyone plead guilty at the arraignment. You plead not guilty. And the reason you do that is you want to have time to look at the discovery. You want to have time to talk to your attorney before you come back and have a called change of plea. And it's called change of plea because your first plea was not guilty. But let's say there's no agreement. Let's say the government doesn't offer you a plea agreement at all. They're like, no, we're going all the way to trial. Like, you don't get any break at all. You are not entitled to a plea agreement. You still get to say, no, I don't want to go all the way to trial. I don't want all this splashed across the news or in front of my friends and family. I'd like to plead guilty and save my family the heartache, save maybe resources if you have a retained attorney, and just plead guilty. Or sometimes you're in hot negotiations with the government and you guys just can't reach an agreement. And you say, you know what? I don't want to abide by all the terms you want to give me. And one of those terms that the government's almost always going to ask for in a plea agreement is for you to do something called appeal any potential waivers, an appeal waiver. And so if you don't have that appeal waiver, even though you've pled guilty, you are still open to all the kind of rights you have, and you're not bound to give away any of your rights or bargain away any of your rights to the government. So some people are like, you know what? I will take my chances. I will plead guilty because I don't want to agree to the restrictive things you have within your agreement, government, and I'll take my chances, and then we'll see where things may go.
Yeah, and I think people forget that. They forget that this is an agreement with the government. It's a contract. And that contract, when we go before a judge and somebody's going to plead guilty, the first thing the judge does is he asks the government to summarize the plea agreement. And what the government has to do is you have to explain both what you're given, because you got to give them something, and what you're getting. And some of the things you might get from a plea agreement, Alice mentioned one, an appeal waiver, where they say, look, I'll never appeal. This case is over. I'm pleading guilty. Case is over. No appeal. No collateral attack. No 2255s. Nothing. We're done. You might do things like waive your right to FOIA stuff. FOIAs, we've talked about that before. It's a big deal. It can be expensive. Prosecutors' offices don't want to have to litigate that. You might put that in your plea agreement. Testing stuff. You might have a plea agreement that says, look, you're not going to come back and ask for us to do a bunch of expensive DNA testing in 20 years. If you're saying you're guilty, then you're guilty and we're done here. We're not going to mess around with this. That might be something else you'd ask for. And if you're a defendant, you might say, I don't want to do that. I want to plead guilty because I want to get the benefit of pleading guilty. And the benefit of pleading guilty, as we'll talk about some more here, is you're accepting responsibility for your crime. You're not fighting it. And that is something that judges take into account during sentencing. So you may want to go ahead and accept responsibility and move forward. Another thing, if you have a viable appeal issue, say you have a motion to suppress. You move to suppress the gun. Say this is a gun case. And the judge rules against you. Well, that all of a sudden, that appeal waiver becomes a really big deal because you feel like you've got a good suppression issue that you want to appeal. And the government's saying, well, if you're going to plead guilty, you need to waive that right. And you're going to say, no, I'm not going to do that. And so I'm going to plead blind. I'm going to plead open and just say, hey, I'm guilty, and then I'll take my chances with an appellate court. Now, you can ask the government to make an exception to the appeal waiver for something like that and say, look, I'll waive all my appeals except for this one issue. You got to admit this was not a frivolous claim. Like, let me go ahead and appeal that. Sometimes government will say yes, sometimes they'll say no. But there are reasons that you might want to plead guilty without pleading guilty via an agreement.
Now we've talked about those open pleas or blind pleas. What does a plea agreement give you then? Why would you go with a plea agreement? Well, oftentimes, though I said that you don't have a right as a defendant to a plea agreement, oftentimes there's going to be plea agreement negotiations because that's how most cases are resolved. It saves a lot of resources if neither side has to go to trial. And once you kind of look at the facts, like the situation that Brett just talked about, if you lost the suppression issue with the gun, you're going to be found guilty. The whole case is about the gun. The gun is allowed in, you're probably going to be guilty. That's why you would plead guilty in that instance. And so if the facts are pretty clear, or you want to essentially agree to something that gives you benefits as the defendant, you can enter into a plea agreement. And there are 3 types in the federal system. They are Federal Rule of Criminal Procedure 11C1A, 11C1B, and 11C1C. Is that right? Yep.
Nailed it.
Nailed it. It's a mouthful right there. So we call them A pleas, B pleas, C pleas. And really quick, just to give you a run through of what they mean, and then we'll go more in depth in each of them. An A plea is that the government will not bring any more charges, and the judge can veto that provision. So you're basically saying, these are all the facts here. You are pleading guilty to this, and the government cannot bring any more charges against you based on this set of facts. If you commit another crime down the road, that's fair game. The judge can veto that because the judge may think, and I'll tell you an instance in one of my cases where that happened. But if they veto it, you as the defendant have the right to withdraw your guilty plea. An 11C1B is a recommended sentence from the government. So the government is going to say, we're going to go in there and we're going to advocate for a bottom of the guideline sentence. That's pretty typical. So you have the sentencing guidelines, a range that is not binding on the court, but we have the calculated range, and the government says we're going to go in at the bottom end. Or they might even recommend a below guideline sentence. Whatever you've agreed to, they're going to recommend it, but it's not binding. The judge can listen to the prosecutor and decide not to go with it. And if you get sentenced to something other than the prosecutor recommended, that's it. You can't withdraw your guilty plea because it's just a recommendation. An 11C1C plea is a binding sentence that if the judge does not accept, then you can withdraw your guilty plea. So that's not a recommendation, but both sides are going in and saying, we have agreed to 10 years. And if the judge says, nope, then you can withdraw your plea in that instance. So that's kind of the broad strokes of the A, B, and C pleas.
And yeah, and I'm gonna let Alice tell her story here in a second because it was a wild one. But something we've talked, you may be wondering why can the judge do that? Why are there circumstances in which the judge can say, I don't want to accept this plea? We talked about this before. The power of the prosecutor is at its greatest before a charge has been brought. That is the circumstance when you have all the power in the world to decide, are you going to bring a charge or not? No one can make you bring a charge. No one can force you to do that. If you want to bring a charge and you can convince a grand jury, that is something you can do. It's some of the greatest power anybody has in the judicial system is a prosecutor deciding whether or not to bring a case to the grand jury. But as the case progresses, the power of the prosecutor drops more and more and more. At this stage, the prosecutor is still pretty powerful, but a grand jury has brought an indictment. You know, there are sort of all these other factors that are involved that are going into this, the things that need to be considered. And the judge has a responsibility to protect the entire process, to protect the victims, to protect the system, to ensure that there's not some sort of shady deal going on here, that there's not some sort of weird injustice going on. And it could be either way. I mean, you could have a C plea with a sentence that the judge thinks is way too high and doesn't want to do. That's usually not what the case is. And so the judge, if the judge is going to be bound by something, if you're going to say, we're going to bind the judge to give a certain sentence, or if the government is going to bind itself going into the future and bind future prosecutors to not bring charges about something, the judge is in a position where he can call out the prosecutors and say, hey, you're going to need to explain this to me. I need to understand why you, for instance, charged 10 counts and now you want to dismiss 9 of them and have somebody plead guilty to 1. That doesn't seem fair to me. I'm looking at the conduct and that doesn't seem fair. And the judge is in a position where they can say, sorry, glad you guys worked out this deal, but I am not going to accept it.
And one thing about these things is you can combine these 3 as well. In fact, the C1A plea, the one where you won't bring any more charges, is almost always part of any plea agreement. So you'll often see like an A and B plea or an A and C plea. And if it's an A and B plea, for example, the A part where you won't bring any more charges is separate from the B in the sense that the judge can veto that part. Just he doesn't have to veto the B part because it's just a recommendation. But you can understand why A is it would be very common in all plea agreements, because if you're going to plead guilty, why would you do so if the facts of what you're pleading guilty to could still lead to other charges? That really doesn't give you finality as a defendant, right? But a judge can veto that because sometimes, especially in kind of wide-ranging cases where there's a lot of different conduct at play, it's not something as simple as a felon in possession of a gun, because that's pretty straightforward. You're pleading guilty to having a gun as a felon. We will not prosecute you for this day when you were found with a gun. But you can imagine, say, I'll tell my story now. I had a tax fraud case, and this woman was a tax preparer, and she had committed like tons of tax fraud on basically all of the returns that she helped to file. It was like hundreds, it may have even been thousands over years of tax fraud. And each of the returns that she submitted was a separate count for tax fraud. And there's identity theft that goes along with it. And because the conduct was similar, right? It was all tax fraud. It was through her tax preparer business. We could bring it under one indictment. But because she had done this a lot of times, we didn't charge 100, tax fraud counts because that's just overkill. But we did do like 10 because we wanted to kind of give a sampling of all the different people that she took advantage of. And the record was pretty clear. These tax cases, especially if you're submitting these through IRS, we have all of the documentation. We had witnesses. It was a pretty clear guilty case. And if she went to trial, the writing was on the wall for her. And she had a good defense attorney who explained this to her and said, you need to take up a guilty plea. And so we reached this agreement, And we went in with an 11C1C plea saying that, Judge, we've agreed to a sentence. And I think the guidelines would have been like 10 years or something. And we agreed to 8 years. So very close, but you can see how she gets a benefit, right? It's a sure thing if she goes to trial that she's going to get something above 8 years, above 10 years, really. And here she gets 8. We go in, and it took a long time to get this plea agreement in place because this lady was not, easy to work with. And we finally reach an agreement. We have to have it approved by the judge, right? It can't just be between the two of you because just like Brett said, no longer once you've involved the public in the judicial system, it's no longer a private contract between the defendant and the government. Now the judge has to bless it. So we go before the judge and we exhaustively explain each of the counts that she's going to plead guilty to. And there's a whole process of questions that you ask the defendant to make sure that it's willing, that they know what's going on, they know what they're bargaining away and what they're getting. And this goes on for about an hour and a half. And the judge says, okay, I'd like a recess. We're just thinking it's a recess that happens because it's been a long time. Everyone takes a, break. We come back and the judge says, nope, I don't accept it. I think that she has done a lot of bad for a long time and she is getting a sweetheart deal from the government. So no. And we're going to trial on the date that trial was originally scheduled for, which was in 5 days. Which is crazy. A tax case is very complex, especially in the federal system, right? I mean, this was not a show up with a gun and be like, here's a picture of him. He's a felon. Here's his, criminal record. And here's his gun in his, hip holster. No, this was wide-ranging double-digit counts of tax fraud. And he's like, nope, I don't care. We're going to trial in 5 days. And this was my first week on the job. And I was like, oh my goodness, here we go. I mean, it was insanity. We went to trial. It lasted a week, which is not short of a trial.
Alice killed it.
I don't know if I killed it, but it was an intense trial, right? We flew in witnesses and experts from all over the country. We somehow made it happen. We went to trial. Unsurprisingly, she was found guilty on all counts, and the jury does not sentence the defendant. They just are finders of fact, and they find guilty or not guilty. So all they did was find guilty, and then it was time for sentencing, and the judge did the sentencing, and he sentenced her to 8 years, which was the plea agreement. I mean,
he just wanted the option.
Oh, he just wanted. You know what? That is a great point, Brett, because depending on your jurisdiction and depending on your judge, you can imagine how the judiciary is supposed to be independent, right? That's one of the great hallmarks of the American justice system. The judiciary is independent. They are not in anyone's pocket. They are not politicians. They are not pro-defendant. They're not pro-prosecution. They are neutral arbiters. That's the ideal. And so when you're telling a judge that they have to do something, which is what an 11C1C plea is, a lot of judges don't like it. And so you'll see a lot of prosecutors actually shy away from a binding plea agreement for the very reason I just described.
Yeah, I don't like to see pleas. And there's very few circumstances in which I think a C plea makes sense. And we've had them. I mean, Alice and I had a case where we had one, and the judge questioned us extensively on it. And we had just had a month-long trial, one of the other defendants, and I was just thinking to myself, please don't make us do this again. And he didn't. And he talked about, that he wasn't sure that the person was going to get enough time, but he recognized sort of the reason the government did what it did, the expense of trial, all that stuff. And those are all factors a judge has to consider when they're thinking about whether or not to accept these plea deals. And look, it's interesting because a judge is not allowed to interfere with plea negotiations. And it may sound like that's what they're doing, but it's not. So a judge can't say, for instance, I'm going to reject this plea, but if you guys come back with 6 years, I will accept that. He can't do that because that's interfering with plea negotiations. All he can do is say, I'm looking at this plea agreement. In my mind, it's not fair. It's not just. I'm rejecting it. Then you can go back and try and work something out and bring it back to the judge, and the judge can sort of make that decision. It's a fine line, but I think you can see why you have this, because you don't want a situation, you got a guy with a gun and the judge looks at the facts, because what happens when somebody pleads guilty, or is convicted by a trial, typically, and certainly in the federal system and in a lot of states, there's a pre-sentence investigation that's done. There's a reason people aren't sentenced the next day or aren't sentenced at the same time. There's an investigation that's done. There's a probation person who works on that. They put together this lengthy document that lays out all sorts of stuff, all the facts of the case, the person's criminal history, the person's personal history, their drug use, mental health issues, all that stuff. The good stuff, the bad stuff, their family, everything. So the judge has all this information. And a lot of times, the way these plea agreements work is you initially, and this is certainly true in the federal system, a lot of times you will initially plead guilty to a magistrate judge. So there's a magistrate judge who is like one step below a district judge. And the magistrate judge, they go through the plea agreement with the defendant. They make sure that they understand all the different provisions. They make sure that the lawyer has discussed it with them. They ask them all the questions. They have a proffer of the facts. So somebody asked about allocution and sort of admitting what you did. That is different in every jurisdiction. In the federal system, you have to proffer enough facts to support all the elements of the charge. So say it's a felon in possession of a firearm, you might have a situation where the defense attorney often will say to the person, on this date, were you in possession of a firearm? Yes. When you did that, were you a felon? Yes. Did you know you were a felon? Yes. And did all this happen, in this district? Yes. And then the judge will say, okay, sounds like you've admitted all the facts, I'm going to find you guilty. So a lot of times the magistrate judge finds them guilty, accepts the plea sort of conditionally. Then this whole big, long document is created. The district judge gets it. It comes time for sentencing, and that's where the rubber meets the road. And you might have a judge who says something like, look, I see that this is a gun case, but it looks like, the bullets that were in the gun might be connected to a murder, and I'm a little confused because it seems like your plea agreement's saying that you'll never be charged with anything that has to do with a gun. Is that going to cover the murder? Because if it is, I might have an issue with that under A, and maybe I need to reject that plea. So you can see where the role of the judge comes in, even if at times it feels like judges have a whole lot of power to sort of mess up maybe what the prosecution and the defense are trying to do. And it certainly feels that way sometimes when you're a prosecutor. When you've taken a lot of time, you've gone through this with somebody, you've worked something out, all the weaknesses in your case, and maybe the judge doesn't know. Alice was saying, that judge is looking at that and says, this is a slam dunk. Well, okay, that's easy for you to say. Sitting up there, I'm the one who's got to fly in all the experts and put on all the evidence and convince the jurors that this matters and everything else. So it is sort of an interesting balance.
Sorry, I'm still reeling from it years later.
And when it was happening, we were like looking at the law, trying to figure out if there was any way to stop him from doing it. Because it literally was. I remember that. I had just started too. Alice and I started pretty close to each other. And there was even an attempt, as I recall, to make a deal right before your opening statement. Like Alice was literally about to give her opening statement, and there was like, what if we did this deal? And that didn't work out either.
We were went to the side of the courtroom. The jury had all been impaneled and sat down, and I was walking up to go give my opening statement, and there was a bunch of hushing and pulling to the side, and we almost reached a plea agreement, but it was kind of was the judge going to accept it? Are we going to have to go through this whole thing again? And then, it was just a mess. It was a mess. So we decided to go through with trial, and it's a great story to tell many years later on Legal Briefs.
I got to say, by that point, everybody on our side was like, let's just go ahead and try this case.
Yeah.
Everybody's here. We're ready to go. Alice has this great opening ready. She had a chart, a demonstrative she was using. I was
explaining how the tax system worked, the tax code with the EITC.
So
it was not. That was not the most exciting. Oh my goodness.
So anyway, those are the different kinds of plea agreements you can have. And one of the things that's important here, and one of the whole reasons you're going to plead guilty, is acceptance of responsibility. We need to talk about sentencing at some point and how sentencing works. But in a lot of systems, there are sentencing guidelines. Certainly in the federal system, a lot of the states have them too. And those guidelines are meant to sort of standardize sentencing and give judges some sort of idea of what similarly situated defendants would get in this case. Because one thing about sentencing is you want to avoid disparities. You don't want two defendants with very similar histories who commit very similar crimes getting massively different sentences. One guy gets probation, one guy gets 10 years. There's some injustice there. So the sentencing guidelines are supposed to say, hey, if you have a guy who has this much criminal history and he committed this crime and there was this much loss and he did it with a gun, there's a guideline, say, 3 to 6 years, which that kind of crime typically gets. And the judge oftentimes will sentence within that guideline range. Well, one of the things that's considered is acceptance of responsibility. And it's not just the judge likes the fact that you said you did it. You also actually get points in these calculations. So if you accept responsibility, depending on how quickly you accept it, how helpful you are, you can get higher levels of points off of your sort of overall thing, and that lowers the range. So it might have been 3 to 6 years, but now you've accepted responsibility, and suddenly it's 18 months to 3 years. And you've got a plea agreement where the government's going to recommend the bottom of the guideline range. So the government's going to go in and recommend 18 months. And you're going to say, we should go even lower. We should go to probation, and maybe you'll get it. So that's one of the big reasons that you want to plead guilty, because you can get that acceptance of responsibility, and it can make a big difference for you. And then obviously in really bad cases, a lot of times the death penalty is a big factor. Some people think this, and it's wrong. Just because you plead guilty in a death penalty case doesn't mean the death penalty is off the table. But you can reach an agreement with the government where the government will take it off the table. And then if you plead guilty, the most you can get is life without parole. And that is a huge benefit. I know a lot of people don't like death penalty for lots of different reasons. But as we talked about with the List case, it'd be really nice if New York had the death penalty right now, even if they never used it, because you could say to him, hey, plead guilty, show us where all the bodies are, tell us everything you did, we'll take the death penalty off the table, we'll avoid a trial, all the humiliation of that, and we'll be done. As it stands, he really has nothing to gain. And we see this sometimes, where you'll have a defendant who, if they plead guilty, even with acceptance, the bottom of the guideline range is going to be the maximum sentence they can get. Or there may even be a mandatory minimum that's going to be the maximum sentence they can get. And they'll say, look, I may have no case, but you never know. The jury might look at me and like me, so we'll go to trial and see what happens. And that's like the most inefficient, really, thing you can have in these kind of systems.
Yeah, absolutely. And you should go take a look at what the sentencing guidelines look like. It really is like a math equation. You have the top part and the axis, and you're kind of figuring out where your criminal history meets whatever crime you have. And it also interplays with whatever statutory maximum is there, because you may have a guideline range that's much higher, but the statute as passed by the legislature has said, well, this, even if you have committed a lot of crimes in the past, you're not going to go to prison for life because you had a gun, for example. There's going to be a maximum sentence for that particular crime, because even as bad as your criminal history is, we've decided that this particular crime doesn't warrant, say, life. So one of the other things that we talked about in plea agreements that are very common is an appeal waiver. And the good thing about plea agreements is not only do you avoid all the costs of going to trial and, the mental toll for victims, family members, the defendant, there's also good finality there. There's not going to be endless appeals of the case. There are kind of carve-outs to that. Most appeal waivers will have carve-outs for prosecutorial misconduct and ineffective assistance of counsel. So if you're sitting here thinking, oh no, all these ineffective attorneys are getting away with being really bad attorneys because most criminal cases end in plea agreements, don't worry. That's a pretty typical carve-out, because you can understand that either prosecutorial misconduct or ineffective assistance of counsel cut against the constitutional rights that are being protected. And sometimes you may not know those things until later. You may not know that your counsel was ineffective because they didn't, tell you about some sort of other plea offer, or they didn't look into some alibi you had, for example, or prosecutorial misconduct. You may not have known that at the time. Maybe that comes to light later on. And it wouldn't be fair that because you were, coaxed into this plea agreement, you don't get to appeal based on this. But other than those two carve-outs, which are really high standards to be able to win an appeal on those issues, you cannot appeal. We still see appeals, though, from people who sign appeal waivers in their plea agreement, and they're usually written pro se from prison, and we can dispose of them relatively easily. So they still cause work for us, but we know that it's not going to be reopened. We don't have to kind of relitigate this case.
And half the time, it's like, are you sure you want to do this? Because if you were to succeed on appeal, that's going to be really bad for you, because you were one of those who had a case where you were absolutely going to lose. You got a great sentence from the judge. You really should just take it and do your time and get out, because if you win this appeal, we'll go to trial and we'll win, and you'll get a sentence that's twice as long. So you might want to just back off, consider why you made that agreement in the first place, and just sort of go with it. But I mean, the fact of the matter is, at this point, the vast majority of cases have an ineffective assistance of counsel claim at some point. They just do. It was always supposed to be, and this is an example of the Supreme Court doing something because they thought it was a good idea without really understanding the practical consequences. When the Supreme Court decided Strickland, the whole thing was, well, this is going to be really rare because it's such a high standard. Like, you really got to be bad for ineffective assistance of counsel. Like, you're hardly ever going to win, right? And the fact is, everybody files them. Every true crime podcast you've ever listened to, they will tell you the defense attorney is ineffective. Doesn't matter what the defense attorney did, how good they were. They'll always be like, terrible, it was a terrible lawyer. That's the reason he lost, because his lawyer was so bad. If only they had pursued this, they would have won. And then, you look at the record of their actual case, and you see that sure enough, they claimed ineffective assistance, and it was denied everywhere in like 2-sentence opinions, because it's really hard to show. It's almost impossible to show, as a matter of fact. But a lot of people do that, and even when you have these appeal waivers, as Alice said, it's been not definitively determined, but pretty much stated that it would violate due process to not allow you to appeal if your counsel was ineffective, constitutionally ineffective. So you can't really have that in there. The other big thing you'll have is cooperation agreements. So a lot of times you have somebody who's pleading guilty, and they're also cooperating against some person who's associated with them in the crime. And in a lot of jurisdictions, every plea agreement has a sealed cooperation agreement. And the reason for that is, so it's not obvious who's actually cooperating, because you don't want, the guy who's the head of the gang, he looks at 10 guys in his gang pled guilty. One of them has this sealed document attached to it. I wonder who the snitch was, right? So if all 10 of them pled guilty, they all would have a sealed document. 9 of them would say, there is no agreement here. One of them would actually be the cooperation agreement.
And there's no requirement that you cooperate with the government just because you're pleading guilty. The only requirement is that you are willing to say yes to the operative facts that meet the standard for you to be guilty for that crime. So a lot of people think that just because you have a plea agreement with the government means you're absolutely a snitch, or you're undercover for the government. Actually, most of our cases don't have cooperation agreements. And why would you cooperate? Well, kind of like that acceptance of responsibility knocks some points off of your sentencing guideline calculation. Cooperating can also potentially give you that. Not guaranteed, but there are additional things that the government can file to get you lowered on your calculation if you actually give them something of value. It has to be of value. It can't just be because I sign a document. Otherwise, these documents would be meaningless.
And cooperation agreements can be super valuable for a lot of different reasons. One of the reasons is some crimes have mandatory minimums. And mandatory minimums can be pretty crushing. And a lot of times, mandatory minimums stack. And what that means is you get 7 years mandatory for charge 1, 25 years mandatory for charge 2. You can't run those concurrently. Concurrently means for every day you serve on count 1, you're also serving it on count 2. So effectively, you have 7 and 25, but you really only have 25 because once you get to 25, you're out because you serve each day for both counts. When you have mandatory minimums, though, they run consecutively. So you have to serve the 7, then you have to serve the 25. So mandatory minimums can be really rough. But cooperation allows judges to go below the mandatory minimum. So cooperation can be really the most valuable thing you can do. And it's one of the reasons you see it happen so often. And it's so important. I mean, the reason it's like that is if you have any kind of organization, whether it's a drug organization or sex trafficking organization or any kind of criminal enterprise, the only way to get to the top people is for the lower people to cooperate, to tell you what they've done. And if they're not going to get, and they need to get a really big benefit for that, because they are literally taking their lives in their own hands. Because if the wrong person finds out, they may very well not survive. So cooperation agreements are dicey for defendants, but they can be super valuable. Is that everything? Have we covered everything?
I think we covered everything. Let me just look at the chat real quick because you
I was
guys
about
are
to say
so
we
good
have
at
a
asking
live
questions.
We have a live audience, so
they could help us in case we missed anything. Can you pay it forward for cooperation agreements? You mean like build up credit for the next time are you asking if you can cooperate so you can get time off
future
for the
crimes
future
for
crime?
free?
No, you cannot.
no.
Well,
One way you can get extra time, which is sort of a wild thing. So imagine a situation in which you are sentenced to 10 years in prison. And let's say you've served 8. But then you realize there's somebody smuggling drugs into the prison. And you go to the prosecutor and you say, hey, I didn't have anything when you sentenced me, but I got information now. Somebody's smuggling drugs in. And the prosecutor says, okay, let's make a deal. We'll re-sentence you because of what you've given us. And you go in to get re-sentenced. Well, what the judge should do is sentence you to time served. So you served 8 years, 10 sentence. I'm now sentencing you to the exact amount of time you have served. Go free and sin no more. But if the judge messes up and says, okay, well, that's worth 5 years off your sentence, so now you're sentenced to 5 years, go forth. Well, because you've already served 8 years, you actually do now have 3 years in the bank that if you then commit another crime and say you get 3 years, that just gets credited to your crime and you would not go to prison for it. That is a mistake. It's not supposed to happen. And we try very hard to make sure that doesn't happen. But if it goes that way, you would have time in the bank that you could apply to your future crimes.
That's awesome. Okay. So remember, these plea agreements are just that, agreements. They're contracts. So there can be, most of them look very similar across the board, right? Because there are certain things you can't bargain away, for example. There are certain things that make sense for defense counsel to always ask for. One thing that a lot of people ask about is whether you get immunity if you cooperate for additional crimes or for something like that. And that is something that is asked all the time, especially if you have a plea agreement and you are testifying against, say, a co-defendant. And I will say, in my experience at least, immunity is very, very rare. And you can imagine why. If you're giving someone immunity, it kind of gives them a blank check to go do whatever they want. That's not good. That's not in the interest of justice. And so that's why most prosecutors play with the sentencing guidelines in terms of calculations, but don't grant you full-blown immunity. And also, you can imagine why if you're testifying against, say, a co-defendant and the cross-examination wants to dig into your ability to lie because you can say whatever you want because you have immunity, that's not as powerful as a co-defendant who gets on the stand and admits to their own wrongdoing, say, in a drug conspiracy. And they're like, no, I'm prosecuted for this. Like, I am not any different than the defendant who's at trial for this. He's getting charged with drug crimes. I am too, because we're in the same thing. I just have owned up to my wrongdoings and I accept what I've done wrong and I'm coming hat in hand. You can see how that's much more powerful than if the co-defendant who was in the drug conspiracy with your defendant was like, oh yeah, no, I have immunity. I'm totally not going to get charged for the exact same thing he is. It seems very unfair. And you can see how that would come off very poorly, not only for our justice system, but for the jury. They might not credit whatever your cooperator is saying.
So I have a couple good questions in the chat room. One of them is, do prosecutors consult with victims? So really, it's going to depend on the case, number one. It's going to depend on the crime. It's going to depend on what kind of victim it is. I think it is always good practice to keep victims in the loop. In the federal system, there are often people who work with prosecutors. And this is true in the state system too, but once again, 50 states, everything's different. So I don't want to bind any states to what I'm saying. But there's often people whose their entire job is to work with victims, to keep them informed, to let them know when's the trial going to happen, are plea negotiations ongoing. So plea negotiation, is a plea been offered? prosecutors never have to get the permission of a victim to enter into a plea agreement. The job of the prosecutor, the duty the prosecutor owes is bigger than victims. It's to the state, it's to the justice system itself, it's to society. Victims are a part of that, but it is ultimately the prosecutor's decision. Having said that, particularly depending on the crime and how personal it is, a murder, sexual assault, something along those lines, some sort of abuse cases, keeping the victim really in the loop, explaining to them exactly why you're doing what you're doing, exactly what the benefits are, what the downsides are, I think is really important, because you want the victim to feel vindicated. I mean, that is a huge part of our job, is to vindicate victims. And so you want them to feel that way, that, we're not doing this because we don't think it's important. We're not doing this because we don't believe you. We're doing this because it's a good outcome. It's going to result in a just sentence. It's going to avoid you having to testify. It's going to end this for you. You'll have closure. I mean, there's all sorts of reasons you might want to do it. So you want to keep victims involved. You want to keep them in the loop. But there is no, in most systems, I don't know if there's any state where there's a victim's veto, where a victim could say, no plea agreement. We're going to trial.
Yeah. Most of it is just kind of keeping them apprised, and they have certain rights. They get to give statements, victim impact statements, to tell the court how they've been impacted by this crime. And we have seen this situation where they haven't liked something about maybe what the prosecutor's done, and they can tell the court that in their victim impact statement. Like, judge, take this into consideration, when you're assessing this plea agreement. I no longer have a mother. I will grow up without a mother because of what this person's done. So, this is how it's affected my life. My life is terrible. This is so, all of those things. So the judge can take all of that into consideration, and sometimes they do. But you can understand why they don't get the veto, because it is larger than just them. It is all victims writ large, all potential victims in the future. It's society and the community that they live in. So this has been a really interesting conversation. There's probably a lot more we can talk about, but I hope this kind of demystifies the plea agreement process for you, because it's actually pretty straightforward, and almost all plea agreements fall within the confines of what we've described here. They're pretty much boilerplate, with the facts being, of course, to the specific cases. But they all have pretty similar factors that defendants are getting, that prosecutors are getting, and anything outside of the ordinary is probably going to be looked at a little bit harder by a judge, as it should, because the judge is kind of the gatekeeper at this point after the agreement has been reached. So with that said, Brett, is there anything else you'd like to add?
I'll throw one more thing in there, because people bring it up sometimes. Really, you could do a whole episode on it. Just Alfred pleas. They are a little different. And essentially, just at some point, some guy, I guess his name is Alfred, he wanted to plead guilty without admitting he did it. And initially, courts were like, you can't do that. We're not going to let you plead guilty if you're not guilty. If you're telling us you're not guilty, we're not going to let you plead guilty. That just seems wrong. But eventually, the Supreme Court said, no, look, this guy's an adult. He's making a calculated decision. He sees that the prosecution's got really good evidence, and they may be able to plead, to prove their case to beyond a reasonable doubt, which does not actually mean you did it. I mean, this is one of the things that I think confuses people sometimes. Like, just because you're eventually exonerated doesn't mean they didn't prove beyond a reasonable doubt at trial that you did it. It's that new evidence can develop and maybe show that you didn't. Or it can be seen in a different light, or all sorts of different things. And so, essentially, the Supreme Court has said, hey, if you want to plead guilty and say, I'm still maintaining my innocence, but I agree they've got enough to get me, you can do it. And that's basically where the Alfred plea came in. But that's all I have.
That's a good one. And we have talked about Alfred pleas a good bit in, I think, some episode. I can't remember it at this point, because we're in the 200 plus episodes for between our two podcasts at this point, which is pretty crazy, Brett. I'm pretty excited for us to have so much to talk about and so much more to talk about. But You
I
guys
can't
are
believe we
awesome.
haven't run out of things yet.
I know. I was going to say, well, it's because of our amazing listeners who give us so much good recommendations for cases and for legal briefs topics. Please keep doing it. If you have any additional questions after listening to this episode, let us know. Maybe we'll do a follow-up and we'll try to answer those additional questions. But thank you guys for those of you who've joined us for this live recording, and thank you guys for always supporting us here at Legal Briefs and as well as over at the Prosecutors Podcast. We love hearing from you, so feel free to give us your thoughts on Twitter, Facebook, Instagram. We are at Prosecutors Pod, or email us at prosecutorspod@gmail.com. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs.
Killed it, Alice, as always.
Killed it. Killed it. Killed it.
There's more people here tonight than there were yesterday.
Because they thought this was Adnan. Sorry, guys.
We're just going to start advertising we're doing Adnan every time. We're not actually going to
It's
record
gonna
the
be
last
over,
Adnan episode
and we're
for
gonna be
a
like,
year.
Adnan,
Yeah.
we've changed our minds. Oh my goodness. That's right. I'm curious. How many of you came only because you thought it was Adnan? But they stayed.
They did. They did stay. Very, very proud of you.